Ladies and gentlemen, in the presentation I talk about a practical topic, the minor's right to self-determination in healthcare, which topic is in the borderlines of family law and health law. The person who uses or receives healthcare, that is the patient, has detailed rights and obligations under the Hungarian Healthcare Act. This includes the patient's right to self-determination in healthcare, which in a broader sense includes several separate patient rights. This includes, inter alia, the freedom to choose a doctor, the right to informed consent to healthcare, the right to refuse treatment, the right to medical confidentiality and disposing of medical records, and the right to access medical records. A patient with full legal capacity can exercise these rights fully independently, while for children the right of self-determination is typically exercised only with the involvement of a statutory representative. In my presentation, I would like to present two areas: the issue of decisions related to the child's health care and the child's right to medical confidentiality and access to health care documentation. The next topic is the issues of consent to health care. In the exercise of the right to self-determination, patients are free to decide whether they wish to receive health care and which interventions they consent to or refuse. Patients have the right to participate in decisions concerning their examination and treatment. We might think that, in the case of a minor, these rights can be fully exercised by the parent, who most often acts as statutory representative, but this is not always true. Under the provisions of the Healthcare Act in force, the parent, statutory representative, has a much narrower scope of control over the treatment of a minor child than his or her own. The parent's exercise of the right to consent is limited in two cases. On the one hand, the consent of the parent, statutory representative, must be obtained only before an invasive procedure. Thus, the consent of the statutory representative is required for any surgery or invasive diagnostic procedure. But the child's examination or medication can be carried out without parental consent. On the other hand, even in the case of invasive interventions, the statement of the parent, statutory representative, must not adversely affect the health of the sick child, in particular not lead to serious or permanent impairment of health. This means the parent may only make a decision which is in the best interest of the child. However, the 1997 health law regulated in capacitated minors and minors with limited legal capacity in the same way. The Constitutional Court's decision was an important step in the development of the right to self-determination in healthcare of minors. According to the Constitutional Court's decision, it was necessary to establish different rules for persons lacking capacity and persons with limited legal capacity. However, the Healthcare Act in 2022 only granted a broader right of self-determination to minors over the age of 16 in two cases. On the one hand, a minor over the age of 16 may waive the right to be informed unless he or she needs to know the nature of his or her illness in order not to endanger the health of others. On the other hand, the law allowed minors over the age of 16 to nominate a person with legal capacity who is entitled to exercise the right to information, consent, and refusal on their behalf. Thus, a girl or a boy over the age of 16 can also nominate an adult boyfriend or girlfriend or even a separated parent or grandparent to give consent to a particular medical procedure, even if it is invasive. An essential rule, however, is that this right is unlikely to apply to termination of pregnancy. Furthermore, we shall mention that from a date protection point of view, there is also the concept of a mature minor, because the prior consent or approval of a statutory representative is not required for the processing of personal data from the age of 16. Differentiated rules for minors are fully justified. For example, in many countries, the law recognizes the concept of a mature minor, which allows, for example, in the UK, a minor over the age of 16 to give valid consent to any medical intervention. In my opinion, the Hungarian health legislation should also give more rights to minors with limited capacity to act, especially over the age of 16. On the other hand, the question may also arise that in the case of a consent to surgery, the consent of one parent is sufficient, or whether the consent of both parents is required. In the case of joint parental custody, the Civil Code allows a parent to make an autonomous decision in the best interest of the child in the case of joint parental custody only in cases requiring immediate action, without delay and without notifying the other parent. This allows to conclude that invasive interventions on a minor child require the consent of both parents, which can only be waived in the case of a need for immediate action. If the parents are separated and have not yet settled the issue of exercising parental custody rights over a minor child, they will continue to exercise them jointly. However, a parent's statement mustn't adversely affect the health of the sick child. The necessary surgical intervention may be carried out in the child's best interest, despite the dispute between the parents. Separated parents can also agree to share the rights and responsibilities of parental custody. In this agreement, the parents can, in principle, also arrange that only one of the parents, for example, the parent with a medical qualification, exercises the parental statutory representatives' rights necessary for the health care of their minor child or children. And in the case of such an agreement between separated parents, or if the court grants exclusive custody rights to only one parent, only the consent of the parent exercising parental custody rights is required for invasive interventions on the minor child. The right of the separated parent to make decisions only on matters of substance concerning the child's fate does not include the right to consent to invasive medical interventions on the child. As has been said, where only one parent exercises parental custody, only that parent is entitled to all information relating to the child's medical condition and care. The Family Law Book of Civil Code provides that the parent exercising parental custody is obliged to inform the parent living separately of the development, health, and studies of the common minor child. This can lead to an interesting situation where the minor child has an accident while he or she is with the separated parent, for example, falls off a swing or falls off a bicycle or skates, and suffers a limb injury requiring surgery, but the custodial parent is unavailable or would be disproportionately delayed in locating and attending in person. This is because in strict compliance with the Health Act and the Family Law Book of Civil Code, the separated parent staying in the hospital can only give consent to the operation if other relatives living in the same household as the child have not done so or are not available in time. This situation could seriously infringe the rights of the separated parent. One of the most complex areas of this topic is right to medical confidentiality and access to medical records. This topic connects to data protection rules as well. We will see that the relevant legal rules are complex and in some way are really unrealistic. An essential element of the doctor-patient relationship is that it is not only the doctor providing information to the patient, but the patient also reveals personal secrets to them. The obligation of confidentiality is the oldest medical ethical norm, which predates the obligation to provide information, as it was also part of the so-called Hippocratic Oath. Both adults and children have the right to medical confidentiality. What a child tells a doctor or a nurse must be kept confidential in the same manner. An exception to this is if it is important for the child's health care that someone else knows this information. It can therefore be concluded that medical confidentiality towards third parties is an obligation of the doctor for both minor and adult patients. However, the current legislation only indirectly provides information on whether and when a minor patient has the right to medical confidentiality vis-à-vis their parents or legal representative. The patient has the right to make a statement about who can be informed about their illness and its likely outcome, and who is excluded from partial or full access to their health data. In this regard, the Healthcare Act does not give minors an independently enforceable right, and only the parent or legal representative has the right to make a statement in such cases. Under the current Hungarian legal provisions, a minor over the age of 16 can request confidential treatment of their confidential medical information against their parents or legal representative by designating another suitable person as the person entitled to receive such information. The patient has the right to access and become familiar with the information contained in their medical documentation. It is a fundamental provision that the medical documentation is provided by the healthcare provider, but the rights of the data therein by the patient. Accordingly, the patient has a number of rights, such as being informed about processing of their data in connection with the treatment, access to their medical data, access to medical documentation, and the right to obtain extracts or copies thereof. Current Hungarian legislation doesn't distinguish between minor and adult patients in terms of medical confidentiality. However, the general rights of access to medical documentation is a little more nuanced. However, the right of access to the medical documentation of a minor with limited capacity is also due to the child as an independent individual, and in this respect, minors aged between 14 and 18 are considered equivalent to adults with legal capacity. A mature minor aged 16 or over can also designate a person to exercise this right, but in the absence of such designation, the parent with legal representation rights will also have access to their medical documentation. On the basis of the above, it can be established that when, after a divorce, a parent or even a grandparent separated from their child, grandchild, and not entitled to exercise parental rights, wants to obtain information directly about the child's, grandchild's health care and condition, they are often outraged to find that only the person or parent who holds legal representation rights is entitled to do so. In the absence of joint parental supervision rights, even in such cases, the separated parent has the same rights as the person with legal representation, the parent raising the child, only in relation to important material issues concerning the child's fate, but not in relation to the child's health care. Therefore, in the absence of a decision granting joint parental supervision rights, the doctor is bound by medical confidentiality vis-à-vis the parent living separated from the child and all other relatives, and is only released from this obligation if the parent, legal representative with parental authority, consents to the provision of information. In my opinion, however, a separated parent or grandparent who is not entitled to exercise parental rights should also have the right to inquire about the health status and care of their minor child, grandchild, to obtain information from the healthcare provider or doctor. The law gives minors over the age of 16 the right to designate the person who has the capacity to act and who must be informed. It is, however, unrealistic that a child should have to give the separated parent written authorization with strict formal requirements to exercise the right of informed consent and the right to access medical documentation in their place. On the other hand, this option only applies in the case of a child over the age of 16, while a separated parent should also be entitled to access health data qualifying as confidential medical information for their infant child. Now, I would like to introduce a concrete case which can show the unsustainability of the current rules. The father, a person with medical qualifications, turned to the patient right advocate because his ex-wife, the child's mother, who based on a court ruling had sole parental custody of their 17-year-old daughter, who had broken both arms and was in hospital, gave instructions that the father could only visit the child for 2 hours a day and could be provided any information on or access to her medical documentation. The daughter was scared and uncertain in front of the doctor and the nurse, and in the father's presence she stated that she would only agree to the operation if her father thought it was a good idea, and she wanted him to decide on the matter. The father, against his ex-wife's orders, asked the doctor to let him review his child's medical documentation. After consulting the hospital's legal counsel, the treating physician refused the request, claiming that his ex-wife didn't agree and that, given she was the legal representative, there was nothing he could do and that he was really sorry. The father asked the patient advocate for help, among other things, in accessing his daughter's medical records. The question arises as to what extent a minor of limited capacity over the age of 16 can have a say in their health care, even independently of the consent and approval of the parent who exercising parental authority. The minor in the above case, in the presence of her father, stated in front of the doctor and the nurse that she would only agree to the operation if her father agreed. As she said, "I would like my father to decide in this matter." During the investigation, it was established that the minor's declaration designated her father as the substitute for the exercise of the right of consent and refusal of care, in which context the minor's oral declaration was sufficient for such designation because both arms were broken and thus she was unable to write. In this case, the law also considers an oral statement made in the presence of 2 witnesses to be valid. If the minor over the age of 16 had not exercised the right of designation, the legal representative would have been entitled to both the right of informed consent and the right to access medical documentation. Therefore, this was not a situation where the mother exercising parental custody and legal representation, but on the contrary, in fact, only the father's legal declaration in relation to the operation could be taken into account. The legal declaration of the legal representative was invalid. Conclusion. As a conclusion, closing remarks, I would like to emphasize that this legal provision is in no way sustainable, first because it is only applicable to minors over the age of 16, And secondly, because it makes the right of a parent who also loves their child and is equally concerned for the child's fate and health, but doesn't exercise parental authority, to be informed and to have a say in health decisions. In my opinion, the legal regulation that requires the parent exercising parental custody rights solely to provide information to the other parent on development and health of minor child is not sufficient. The right to information and decision on the child's health care and condition should be regulated among and equivalent to other relevant issues affecting the child's fate. On the other hand, the Healthcare Act or Family Law Book of Civil Code should be amended to allow the parent who doesn't have parental authority to exercise the right to consent to surgery earlier in the legal order in the event of invasive surgery for a child who has been injured during contact, if the child's legal representative unavailable or if reaching them would entail a disproportionate delay. Thank you very much for your attention.